All right. Thank you, everyone, for joining us today on this important webinar on the overview of the Corporate Transparency Act. My name is Fawaz Baum. I'm the president of the DFW Musim Bar Association. As a quick introduction to the DFW Musim Bar Association, we're a non-denominational, non-political union of lawyers and law students of Muslim faith, open to all lawyers and students of all faith traditions to join us in any of our events. We seek members who wish to serve and protect the constitutional rights of Americans with a special focus on minority and American Muslim communities. We align together to give back through community service, pro bono legal work, and to promulgate legal information, CLEs such as this one, as tools for social empowerment to our members and the community at large. Please follow us on our social media pages. We're on LinkedIn, Instagram, Facebook. And please visit the dfwmusimbar.com page, which is an amazing platform for you to register as a member and really get more up-to-dates and connections and network with our amazing community. Just a quick blurb about a couple of events that we've got coming up. We have a citizenship workshop with the city of Dallas this weekend, August 24th, where we will be volunteering with a bunch of different organizations helping processing of citizenship applications. You don't have to be an immigration attorney to help. There are many ways to help, and there's training that's also provided, and the applications are all reviewed before the applicant leaves. We also have an event with Zaytuna College on August 29th at Arwa's Coffee Shop in Frisco, which is a new program that we just posted about today. We're very excited to do that because that's right at the cusp of ISNA that's starting up the following weekend as well. We then also have an event with the Oak Cliff Empowerment Center on September 29th. We had Coffee and Connections on August 10th, which was a great opportunity for our membership to get together, and we're hoping to do more of those. So we'd love to see more of you there. And then a quick plug for the NUML conference, which is a national conference that is going to happen on October 25th through the 26th in Chicago. And throughout the years, we have a variety of picnics, galas, iftars, pro bono opportunities, community service opportunities. So really hope you join us and continue to stay engaged with our amazing growing organization and with everything that the board and our members are trying to do. So with that quick synopsis of the DFW Musim Bar Association, it's my pleasure and honor to introduce the two speakers that we have for you today. We have Cheyenne, who is an attorney at Jackson Walker in their Dallas office. He practices in the firm's corporate and securities group and focuses on securities law, compliance, investment funds, and mergers and acquisitions. His professional endeavors are complemented by his active participation in the community and interfaith initiatives, showcasing his dedication to both legal excellence and social responsibility. We also have Antonio. Antonio graduated from the University of Dayton School of Law in 2008 with a focus on business law. After passing the Maryland Bar in 2010 and the Texas Bar in 2016, he was admitted to practice before the Supreme Court of the United States in 2017 and the United States Tax Court in 2023. Shortly after passing the Maryland Bar, Antonio founded the law office of Antonio M. Glenn, LLC, a solo practice specializing in small business consulting, estate planning, and tax controversies. The practice has since grown and rebranded as AMG Counsel, and you see the beautiful logos, with offices in both Maryland and Texas. Antonio is actively involved in the legal community, serving as vice chair of the Corporate Counsel Committee for the State Bar of Texas and a member of the Collin County Bar Association. He also focuses on the board, he also serves on the board of multiple nonprofit organizations. Additionally, Antonio is pursuing a state certified estate and probate attorney in Texas. So that'll be something of an amazing achievement here very soon, inshallah. Dedicated to giving back, Antonio regularly provides pro bono estate planning, probate services through wills, through DVAP, and in his spare time, he enjoys scuba diving, playing flag football, and training for sprint sprints as well, and clearly also contributing to CLEs like this one. At the end, we'll have a Q&A session, and feel free during the session, you can drop in questions in the Q&A box, and I'll filter through those and keep an eye on them. And we'll have a CLE code at the end that we'll give you for you all to get credit for attending today. Thank you again, and I'll turn it over to our esteemed colleagues and presenters for this presentation. Thank you, guys.
Thank you. Okay, we'll get us started. And again, Antonio Glenn here with Cheyenne. And we'll get started. So today we're going to go over an overview of the Corporate Transparency Act and what that entails. Not sure how many of you are into the business or corporate practice, but there's some other information and details you would probably even need to know if you're an estate planner or you're doing other filings for different clients that you may want to be aware of. So on the agenda today, we have an overview, we have deadlines, which are important. Again, penalties for failure to comply, what needs to be reported, and then what is a reporting company, and then the exemptions to follow. And then the most important piece are the beneficial owners. We'll talk a little bit about trust because there is a key piece for that, which I think most people miss over. FinCEN identifiers in the next step. So I'll let Cheyenne start and give us a quick overview and go from there. Thank you.
All right, thanks, Antonio. Afternoon, everybody. Thanks for joining. So an overview of the CTA. The CTA has been on the books for a couple of years now, went into effect for the reporting requirements the 1st of January of this year. The stated purpose is to combat money laundering and other illicit financial crimes, right? The idea being that if you have shell companies that you know who's behind those shell entities, the reports require you to list individuals and not just other entities that have a beneficial ownership stake. And like Antonio said, we'll get into what exactly it means to have a beneficial ownership stake for purposes of CTA reporting. These reports are filed with FinCEN, which is the U.S. Department of the Treasury's Financial Crimes Enforcement Network. They are filed electronically through their website. And if we have a moment at the end, well, we can actually maybe able to walk you through sort of a sample filing, what it looks like. But you can either log into the FinCEN website and just fill out information on the website itself, or download a PDF that's a form, and I'll let you electronically submit using the PDF. As we'll discuss, the CTA form requires information about individual owners. This includes information about their addresses, and also to upload government-issued IDs, passports, driver's license, so on and so forth. And in addition to beneficial owners, for companies that were formed on or after the 1st of this year, 2024, you also need to report company applicants, and we'll discuss what that entails later on in CLE 2. If anything changes in terms of the addresses or the company's information, the owners, an amendment is required as soon as possible. And we're back to the, we're on deadlines now? Okay. And there was a constitutional challenge to the CTA that played out in March. The plaintiffs in that case actually won. Unfortunately for practitioners, the government is only enjoined from applying the provision of the CTA to those particular plaintiffs. So for the rest of us and for our clients, the CTA is still in full force in effect until further notice. Now, some deadlines for when you need to file a CTA report. There's really two prongs to this. It depends on when the company was formed, right? And this is assuming that the company is a reporting company, not exempt. And again, we're going to get into what the exemptions are later on. But if you have a company that was formed before the 1st of January of this year, they have until the end of this year to file their CTA report, the 31st or the 1st of 2025. If the company was formed on the 1st or after the 1st of this year, they have to file the report within 90 days. And starting next year, companies are going to only have 30 days to file the report. So the 90-day, the 3-month window only applies for 2024, and 2025, that shortens to 30 days. And if you do have those amendments, like I mentioned before, those have to be filed within 30 days of when you figured out that an amendment was needed. think we can go to the next slide, Antonio. You want to take on the penalties?
Oh, yeah. So the penalties are pretty steep. I know when I'm informing my clients and making them aware of the CTA requirements, I bring up the penalties because it's really stark. They're unlike other penalties, these are civil and criminal penalties. And you can get that up to $10,000 fine. Normally in their initial reporting, if you were out of compliance, it was $500 a day to be out of compliance for this FinCEN reporting. Now they seem to have this cap of 10,000, but you can also have up to 2 years in prison for any person who willfully, again, does this, either provides this false or fraudulent information. If they fail to complete a report to FinCEN, that's another reason as well. And it may be also to someone who causes the reporting company not to report. So if you're an attorney such as myself, who are working with companies who are forming, it's imperative on you to make sure that you're complying with them, maybe getting them your FinCEN identifier number or providing them with the information that they need. I think in some cases, when you have a partnership or people are coming together for maybe a multi-member LLC, I think Cheyenne can speak too, on the bigger firms, we're requiring them to provide that BOI information. So the person who's handling, maybe the manager or member who's handling that is able to submit that information. You also do have the safe harbor where, if a person has submitted some inaccurate information, they can correct that. And you can see here. And Sharon, you might want to talk a little bit about what Jackson Walker is doing to kind of ensure that you capture that information.
Yeah, so at least for our firm, and of course, this isn't advice on how everyone else should manage their practice. The lawyers here at JW will not serve as organizers anymore because of this potential fear that, hey, if we serve as an organizer, we'll have to be listed as a company applicant, and then do the penalties for not reporting fall on the individual attorney. And so what our MO is that we're going to have the clients sign as organizers, and then we use a third-party service to file those filings. And when it comes to the company applicants, which we'll talk about more in detail, the lawyers here, JW is not considered a company applicant. We consider company applicants to be the client assigned as the organizer, so they'll get their FinCEN ID or provide their information for the filing purposes. And then we also have the FinCEN ID of the service that we use to initiate that filing. Now, of course, for some firms in which the attorneys are signing as organizers, that's not feasible. So like Antonio said, if that is your practice, then just keep in mind that, you schedule those deadlines and you push the client to file, or at least try to provide the information that you need to be able to make the filing before that timeline expires.
Yeah. So what must be reported to the BOI? Again, the reporting company itself, which is the company that was created, and we'll go more finely detailed definition on the next slide. And then it's the company applicants, what we were just speaking of a little bit, which could be an individual such as myself, a service who actually does the physical filing of it. Shane talked about a third-party service. I think they're like CorpNet and some other third-party entities out there that can be used. And then it's really the individual primarily responsible for control of that filing. So for any solo practitioners out there themselves, I mean, even though sometimes I hear some CPAs filing and setting up entities, they may want to be aware of that. So if you have someone who's in that adjacent type field, who may need to be aware of that, they're a part of that too. And of course, the beneficial owners. I think the company applicant piece is a piece that sometimes gets missing, but I think it's good for everyone to know that they're responsible for helping to either get that information and submit that report.
Yeah.
So reporting company. Oh yeah, go ahead. I'm sorry.
Okay. I was just going to say one thing I thought about, Antonio, on the last slide is when I was talking about the organizer. So our analysis is where the organizer falls into that second bullet point, right?
Mm-hmm.
That this is the person that's signed off on the filings, approved the filings, and therefore is responsible for the filing. So under that definition is where we say, hey, we don't really serve as the organizer. Client, you creating the entity will be the organizer and thus be reported as a company applicant. So this is some more background on why the client signing as organizer would be considered a company applicant in our opinion.
Definitely. Thank you for that.
Okay, so now let's talk about who must file reports. So this is sort of a high level overview, and then we'll get into the exemptions later. And as a general note, this entire presentation is pretty high level, just so people get to understand like what is a CTA, what's required in the CTA. But of course, every reporting company, every filing is a very fact-specific analysis. And we'll talk about some resources at the end. FinCEN has a guide that walks you through the exemptions in much more finer detail, and that's a good resource to have to determine whether or not you have, or rather your client has a filing obligation or not. But what are reporting companies? So unless they're exempt, these are all domestic corporations, right? This includes your LLCs, your partnerships, your, in some instances, trusts, right? Nonprofits, we'll talk about that. Created through the filing of a document with the Secretary of State of a state in the United States. Now, this means by implication that things like DBAs, sole props, general partnerships will fall outside the scope of this requirement because those aren't created through the filing of a document with the Secretary of State. There was some back and forth about, hey, actually, we file a DBA, that is a filing, but you're not creating an entity through that filing. I think that's the key differentiator there. Now, it can also apply to foreign companies as well, to the extent that they file to do business in a state within the United States. So you have domestic companies and then foreign companies if they file the document to do business in one of the states of the United States. I think we can go to the next slide of exemptions.
Yep.
So this is a high-level overview of the exemptions. Like I said, there's a much larger list, but this sort of captures what the biggest ones are. So first and foremost, if you're a governmental authority, if you're a bank, or if you're a securities broker or dealer, registered under the Commodities Exchange Act, if you're a pooled investment vehicle and meet certain criteria through being a pooled investment vehicle, or if you issue registered securities, you don't have to file. The thought behind that is the government already has your information, right? I mean, you already made the necessary filings, your information's out there. They know the people behind these entities. No filing is required at that point. You're exempt. Investment companies that are registered also don't need to file. Investment companies that are exempt, 3C1 and 3C7 companies, may have a filing obligation, but that is where this fact-specific analysis comes in, because not only do you have to be 3C1 and 3C7, but you also have to be advised by certain entities such as a bank, a credit union, a registered broker. So that's why it's a very, very fact-specific analysis when it comes to, hey, if you're a 3C1 or 3C7 fund, are you actually exempt from filing or not? Insurance companies and producers are also exempt from filing. Certain tax-exempt entities are exempt, and Antonio is going to talk about the sort of key details there, because it could be the case where a nonprofit starts off as being a reporting company, but later on becomes exempt, and he'll get into the details there in one of these next two slides. But the key differentiator here is you have to be tax exempt. Just forming a nonprofit corporation doesn't automatically take you out of the fold of having an obligation to file under the CTA. Now, along with that, if you're an entity that's formed to operate or provide financial assistance or govern a tax-exempt entity, you would also be exempt in that case. So think of your holding companies, for example, right? I mean, if you meet those prongs, you very much are likely exempt, both on the nonprofit side as a tax-exempt entity, but then also the entity that's providing support or governance for that nonprofit. That's tax-exempt.
Okay, so I'm going to talk a little bit about the niche and the nonprofit CTA filings. For the most part, 501c3s, their status, they're not exempt. I mean, they're not exempt from they are exempt from the CTA reporting requirements. I think I made a typo there. but there is a process. So for the most part, any organization created before January 1, 2024, they're exempt. They more than likely have it's a 1023 letter that you get from the Internal Revenue Service that says you're tax exempt. You file a similar letter to the state of Texas and you're exempt. So you're clear, you're free and clear if you have that. Now, I set up a lot of nonprofit organizations. And so when you set up a not-for-profit corporation in your state, normally there's a waiting period before you file for the 1023 from the IRS. It normally takes at least 3 months. So in this compliance period, you have 90 days from the creation. So technically speaking, it's still gray if you form a not-for-profit corporation and later on you get your 501c3 letter really quickly, you may be able to use that to show, hey, it's retroactive from the IRS, so we don't have to comply or we don't have to file BOA information. So, in the most part, moving forward to next year, you won't have a 90-day window. You'll have a 30-day window. And most of the time, organizations formed in 2025 will have a less room to be able to get their 501c3 exemption and be totally exempt. So, like Shannon mentioned, you'll set up a not-for-profit entity. More than likely, the beneficial owners will report 1 year that they have it. And then once they get their 1023 letter, they'll be able to go in the following time and say they're exempt. And there's still a nice burden that is relieved from that, because now you don't have to worry about, if you're exempt, you don't have to worry about changing your address. If you change your address, you have to go to FinCEN and change your address. If you have board members fall on and off who have some type of control, you don't have to worry about going to FinCEN to update that information, because that could put you out of compliance, and then those penalties and things start to accrue, and then you go back to the penalties for not reporting properly. Just do that. So the exemption will save you some time and stress, and that's really what you need as a nonprofit. Here also, if you have your nonprofit status, and many nonprofits don't always keep up with their compliance records, sometimes they may lose their 501c3 exemption and they can go back. Many times you can go back and restate it, but once it's gone, you have about 180 days to go back and try to get that resolved before you have to resubmit your report to the BOI and CTA. So one of the examples I always get is, I think many of us maybe serve on nonprofit boards. Maybe you're helping out your local masjid or mosque or some other entity, and their board is always coming. Do we need to file? Do we need to file? For the most part, I would recommend making sure that you have their 1023 letter. You're able to go to the IRS site and you can search tax exempt entities, make sure all their 990 filings are been submitted and that they're active. And then just keep a record on that of yearly, making sure that you maintain that so they don't lose that tax exempt status and go from there, that they stay in compliance. Whether HOAs, so many nonprofits that we're not thinking about. And if you help set those up, remember, even if it's a not-for-profit entity and you're the company applicant to get your FinCEN identifier number and make sure you comply with that. For nonprofits, that's what I'll put. So we'll get into some large company exemptions and I'll let Shay and talk about those.
Yeah, so this is one of the other exemptions that we're just going to flesh out a bit, because I mean, the larger the company that you have, the more pronounced and burdensome a potential CTA filing might be. So it may be the case that if you are actually large enough and meet these 3 criteria, and then that large company is exempt from filing a CTA report. And so what are those criteria? So it has to meet all of it. It's not one or the other. The first is you have 20 full-time employees in the US and you can't consolidate. So if you have multiple affiliates, that doesn't count. The company that's the alleged reporting company itself has to have 20 full-time employees within the United States. If that's met, then you ask, okay, is there a presence of that company at a physical space here in the US? We'll discuss later on that PO boxes don't count. So they actually own or lease office space that's not shared with any of those affiliates that I mentioned back in the first part of this test. If that's good to go, then you have to look at federal income tax filing. Have they filed in the past year, a return that shows more than $5 million in gross receipts, with some exceptions, sorry, not exceptions, some qualifiers as we net of returns and allowances. Unlike the first part of this test where you cannot look to affiliates, for the filing of the tax return, if the corporation is part of an affiliated group and there's a specific definition for that in the tax code, then you can look to that affiliated filing to meet that financial threshold. Otherwise, if you fail one of these requirements, then you would at least not qualify for the large company exemption. That doesn't mean that you may not qualify for another exemption. And I think,
Yep.
And so another common one that we're seeing is the subsidiary exemption. So if the ownership interests of a reporting company are controlled or wholly owned, directly or indirectly, that language is actually from FinCEN itself, by a parent entity that itself is exempt. Aside from being a pooled investment vehicle, an MSB transmitter, an inactive entity, or an entity assisting a tax-exempt entity, then that subsidiary would also be exempt from filing a CTA report. So an example we have on the slide here is that if you have a wholly owned sub of a parent that itself qualifies for a large company exemption, then that wholly owned sub is itself exempt from reporting under the CTA. And as an aside, one of the resources we're going to mention towards the end of the presentation, that FinCEN has actually created an FAQ on their website, which is really good for being a government website in terms of providing examples and walking people through a checklist approach to seeing whether or not a particular company might be exempt from reporting requirements.
All right, thank you. So next we'll discuss inactive entity exemption. And these exemption applies, of course, you can see to any entity in existence before January 1, 2020, not engaged in any active business, not owned directly or indirectly by a foreign person, again, not generating any funds and not holding any other assets. So an inactive entity, which there are many entities that lapse, but remember that date, January 1, 2020, is still the date that you have to comply with. So if it's something after that, I believe the guidance is you still need to report on that. And this is why on some sides, we've been pushing clients to dissolve their entity, to shut them down so they won't even inherently miss or be out of compliance with a business they're no longer using.
And one thing, Antonio, I'd like to add to that. Sorry, I'm jumping in,
Yeah.
taking your spotlight here.
Please.
But I think the last part is something that is good to flag in this test, is that the entity cannot hold any assets, including an ownership interest. So if you have those shell companies that are just there to hold ownership interests, that would put you outside of this exemption. So even if you haven't been doing anything with this, say, for example, LLC for a decade, if it exists to hold ownership interests, there's a very strong argument that it actually would not qualify for the inactive entity exemption. To keep that in mind, we're talking about totally vanilla, completely empty companies that have been inactive that could qualify for inactive entity exemption.
Thank you. Okay, so we'll talk a little bit about reporting company information. As you can see, we're about halfway through, so we'll pick up the pace a little bit, but I think we're doing good. But basically, the reporting company, full name, full legal name. Hopefully, we do have some time at the end to show you the FinCEN reporting site. You'll also include all your trade names and DBAs, doing business as, principal place of business, no PO boxes, and what jurisdiction you form your company in, and then your EIN, tax identification number, for whatever entity that you have. Anything to add to that, Cheyenne?
No, I would just say that one thing that's personally tripped me over is we had a client that we needed to file a BOI report for. under the CTA didn't qualify for an exemption, and we're going to file it, and it turns out that never applied for an EIN. And so that was sort of a mad dash to get an EIN on time to be able to file the CTA report. An EIN is required. So keep in mind that, if you have a checklist of entity formation, and if you think the entity is gonna be a reporting company under the CTA, get that EIN because you're gonna need that to fill out the form.
Yeah, and one thing too, you can only get an EIN Monday through Friday. The site is actually down over the weekend. So if you're trying to catch up and do this over the weekend, you won't be able to get that EIN number because the site is down. So always remember to get your EIN numbers Monday through Friday. Who are beneficial owners? Of course, the beneficial owner is an individual who directly or indirectly either has substantial control over the reporting company or owns or controls 25% or more of the ownership interest of a reporting company. And I think that substantial control piece is a big piece when we get into it a little bit later, along with who controls, because I think sometimes, especially in small family-owned businesses, who controls or has substantial control can mean different things, especially if they want to bring kids into some type of succession planning or estate planning type of transition, and they want the kids to take more control or ownership, or have a membership interest where they're able to get the gains out of the business and then leave the control to the kids. So that'll be interesting as well. So what are ownership interests? So this term is pretty much defined really openly: profit interest, options to acquire equity. It can be direct or indirect ownership through these contracts, relationship, or otherwise with other persons. A nominee, intermediary, custodian, or agent, and who has ownership or control or one or more intermediary entities. And so sometimes when I see this, I think a little bit about as an LLC, you have a membership interest, and you can actually contract that out to someone, or you can give someone almost as an assignee or this word nominee some interest in that membership interest that you have. And that can have actually put them in a position where now they're somewhat in control of this, or directly or indirectly over the company, and it might bring them in to having to comply with the BOI requirements. Anything to add to that, Shane?
Just one thing, that there is a look-through piece here, right? If you have an entity that owns the requisite number of ownership interests to be reportable, you would have to look through that entity to determine its BOIs and to file them as the BOIs of the reporting company that you're filing for, right? So, I mean, we recently ran into this where we had a corporation that held 36% of an LLC. So we had to look through to the BOIs of that corporation, get their information to file for the LLC's CTA filing. So keep that in mind as well, because the BOIs, with one very limited exception, which comes to if there's an exempt entity involved as the owner, the BOIs have to be individuals. And so keep that in mind.
Okay, so what is substantial control? An individual exercises substantial control over the reporting company if they're a senior officer of the reporting company, CFO, CEO, even regardless of title, which I can understand that because a lot of people will forego the title, but they still have a lot of control over business and business operations, especially if they're a financial type of investor in that entity. They'll want to have control, even though they may not be named. Here, you also have the authority to appoint or remove a senior officer in that respect. And again, all these are case by case based on the company. This is a good guideline to go off of. And then you also have a reporting company. If there is a director who has influence over important decisions, again, the scope, nature of the business, maybe they're selling or leasing. Are they able to make major loans or investments on the behalf of the company? Can they take out loans and take debt, maybe sell different assets of the entity if they wanted to? Can they terminate the business or have at least some some type of control over either business lines or ventures and going into maybe joint ventures or even having control of the direction on where the company is going. And then approving operating budgets, compensation. So basically you're thinking of someone who really does have influence and direction over the company, or any other kind of control over the reporting company, as having substantial control. So we'll get into another little niche on different LLCs and who has control in those instances to kind of show. We have a slide on some examples of that. So here, again, it may be a trustee acting on a trust, and we'll talk about that a little bit, because the trust can be a different kind of arrangement when it comes to this. So owning or controlling a majority of the voting power or voting rights of the company. Again, rights associated with any financing agreement or interest. So someone may give an equity interest, or make an investment for equity in the company, and even though they feel like I don't have a title, you're still in control and management of this LLC and what it can do. And then you also can do contracts, have some control on directions and deals that the company can make. And so I just feel like, yes, you have a good amount of exercise of control in that situation. And I always kind of think too of what is it? Independent contractor and control mechanism of employee-employer rights, how much substantial control you have over them. In that sense is kind of how I equate it to. Anything to add, Shayan, on that?
No, I mean, I think, you nailed it. I mean, it's, like I've been saying, it's a very fact-specific analysis, right?
Yeah.
Like the first part said, the title just isn't determined. I mean, the title could be pretty heavy in terms of making that determination, but it solely is not determinative, right? You could have a board member that's sitting there doing nothing, has no control whatsoever, and could argue that they're not actually exercising any form of substantial control for purposes of CTA reporting.
Correct. And I think of many of us on boards or the board of directors in and of itself being determined, I think many attorneys sit on the boards of different companies, but they don't have any exercise of control. They may vote, they're more of a think tank for them, when not less of a working board, is what we did use the term a little bit, that you're not a working board, you're there just really as a mind or expertise in your field to offer some information and guidance to the nonprofit board and its officers.
And these are just some exceptions to beneficial owners. So the first category is creditors, right? So just because you have the ability to control collateral because you've secured it under a credit agreement doesn't qualify you as having substantial control by itself for purposes of the CTA. Minors aren't going to be reported under the CTA. You would use the parent's information instead, and there's actually a box on the field that says, hey, if you're a minor, click this, and then you plug in the parent's information or the guardian. And this one gives me law school flashbacks. But if your interest in the company is through a future right of inheritance, did not do well in property law, then that would also not qualify you as a beneficial owner of the reporting company.
And yet, in the estate planning sense, I can see how that would be a conundrum, because you want to somewhat give a gift, but it's basically a future gift of a company to individuals once you pass away. But this will help them kind of not have to comply, be an exception to that beneficial owner rule.
Antonio, if you ask me how the rule of perpetuity applies to this, I'm going to drop off the CLE.
So, I think everyone in here is allergic to the rule against perpetuities, and so we'll save them and spare them now. So here I think we talked a little bit about the information that the beneficial owner and company applicants in the BOI report. So again, the full name, date of birth, address, with company applicant, business street address, and information. So one thing, the company applicant can also get this unique identifying number or a FinCEN identifier, and we'll talk a little bit about that later on. They'll be able to have this number. So instead of always having to give out this personal information from the company applicant, maybe your LLC is your home address and you never switched it because you want to get, save on taxes for the home office expense. there are different reasons why you want to have some anonymity and separation between you and the client and what they have in their report. So for me, the FinCEN identifier number, it includes all of them. And it allows FinCEN to have my information without the public and other parties having that information as well. So it may behoove you to go out and reach out and get that information. Again, hopefully, let me speed through so maybe we can have some time, because it is a simple, it can be pretty easy a little bit if you have the information to go through. So one thing I wanted to talk about was manager managed LLCs and series LLCs. We were talking about substantial control over an entity. And so many LLCs, when they get set up, they can be member managed or manager managed. And so the members sometimes elect to have a manager run the company and be in control of it. They're the member, they have membership interests, so they have the rights to the distribution and money from it, more voting rights, and those higher up decision-making powers to manage it. But then you have a manager who's running the day-to-day operations, right? They're the ones who's doing all the billing. They're really in control while you're off, maybe doing other business ventures or having other LLCs. And so in this structure, it's a layer of control which may require that manager member to file under the CTA. And again, case by case basis, it depends if they need to be a beneficial owner because of this substantial control piece, as opposed to just maybe strict ownership piece. So if the manager exercises that type of control over an entity, they may need to be on that. So it includes key decision-making authority, operational decisions, firing employees, bringing in employees. Maybe they need to make large purchase orders and do everything strategically for the company. Maybe big government contractor in DC, maybe here they work at a medical facility or something, and they're the ones in control of a lot of the day-to-day operations. So please be mindful of those manager-managed ones. You may want to reach out to an attorney and get a consultation on that.
Yeah, and then the second part of the slide is the series LLCs, and that is something that comes up because series LLCs are interesting, right? I mean, once you form the LLC, the series are created by series supplements, not necessarily a filing with the Secretary of State for the additional series.
Right.
And so that's the first problem. The second problem is if you have a client that has dozens, if not hundreds of these series LLCs because you're using SPVs, do you have to file a CTA report for every single one of them? And unfortunately, the guidance here isn't clear. FinCEN is releasing new guidance quite often as practitioners are asking questions.
Yes.
But our practice is, hey, if you have an EIN for the series LLC, and if it's being treated distinctively for tax purposes, then you should probably, until told otherwise, file a report for that series of the series LLC.
Yeah, I agree with you. For some of my smaller businesses, I inform them of the same, because definitely what they want to also have is with these series LLCs, you can change ownership or membership interest for each subpart of the series LLC. So even on the parent company, there may be mom and dad, but then on one of the subs, it may be one of the kids and another parent, or maybe the siblings all together. And they'll have their own financial records, own bank account, and things like that to keep it separate for liability purposes. So in that case, in agreement with Cheyenne, I tell them, hey, look, I think you may want to, provide that information on behalf of this one because it has the EIN. Save yourself, and later on, if you're exempt, then you'll be fine and go from there. But it's still a very gray area.
Yeah. And then I guess as we were talking, Antonio, I just want to take a quick step back and say that, hey, we've been throwing a lot of words out there about substantial control and ownership interest. So we mentioned this, but just to sort of, put the nail in the coffin, so to speak, these are the two prongs that could qualify you as a beneficial owner, right? So beneficial owner is the category of people that need to report. What makes you beneficial owner is either A, having substantial control, which Antonio talked about in depth earlier, or B, having the requisite level of ownership interest, which is 25% in the reporting company. So if you meet either or of those requirements, you are considered a beneficial owner for the reporting company. think,
Oh, okay. So how are trusts implicated? So I'll talk a little bit about this really quick. So this was a little eye opener for me because most of the time when you have clients doing estate planning, they'll set up joint revocable living trust for the husband and wife. But oftentimes they may have a second or a property out of state. And if they're using that as a rental property, they will more than likely set it up under a limited liability company, which they would then address themselves as the beneficial owners of. But then what they'll want to do is retitle ownership of that limited liability company to their revocable trust. And this is where this gets pulled in. So if an individual here may exercise substantial control over a reporting company that directly or indirectly, as the beneficial owner, the trustee of the trust. Normally for a revocable living trust, the trustee will be the trustor, the people who set up the trust. They're the initial trustees for this revocable trust, and they're in it. And even a trustee for irrevocable trust might also be needs to be knowledgeable on this because they do have this type of control over the reporting underlying entity. So through such ownership or control, the majority voting power of the reporting company. So if a trust holds an ownership interest in a reporting company, following those individuals are deemed to have ownership interest in a reporting company, then the trustee of the trust with the authority to dispose of trust assets, a beneficiary who is the sole person, sole permissible recipient of the trust, income and principal, and has a right to demand a distribution of or withdraw substantially all of the trust assets, and of course the grantor or settler who has a right to revoke the trust or otherwise withdraw trust assets. So for the most part, this trustee is the husband and wife. They're the ones who are the grantor and settler. They have the right to, that's why they call it revocable trust, because they can take the assets out, they can rewrite the trust without any penalties, and it's a private document. Most of the time, the trust it doesn't go to a registry. You don't take it to the state. You draft it internally. You get it notarized for the most part, and it's a family internal document. But again, if you bring in this reporting company or this limited liability company or some other entity that you then transfer title over to the trust, now that trustee is more in line to have substantial control and the ownership interest in that reporting company to then have to file as a beneficial owner for that. And so sometimes you have third party trustees. So maybe husband and wife are a little bit older, and then their kids are co-trustees in that scenario. They would more than likely have to reply to be the beneficial owners if they can do these things of having the authority to dispose or trust assets. If they don't have that authority based on the trust provisions, then they wouldn't have to comply, but then their parents more than likely would because they do have the control to manage to dispose of assets or demand distributions. Most of the time, it's the first line beneficiaries who are able to do that. And that's the initial trustees who are also the settlers. So again, to kind of recap that, because it was a lot, you have the trust owns the LLC, trustees more than likely now need to report as the BOIs of that reporting entity that is now owned by the trust. Okay.
and we're actually
Shane?
pretty good on time. Yeah, no, I have nothing to add there. I think you did great.
Okay.
Trusts are not my company. But I think the last part of our presentation before we dish out those resources we talked about and answer some questions, because I do see we have a couple of questions, are FinCEN identifiers. I love FinCEN identifiers. This is why. Because if you look at the actual filing, the report that you have to file, the field, it asks for address, ID uploads, other personal information, right? That sometimes can be kind of dicey to get from a client. And then also, if you're just plugging in people's addresses, if anything changes there, you got to go back and amend, right? And so if you have the same client that has created dozens of entities with you and you've only ever typed in their address, well, guess what? You got to go back and amend all of those dozens of CTA filings because the address has changed. So what we do, and I think this is pretty good advice, 'cause it's super simple to get, is get a FinCEN ID. The website is there. Go to FinCEN ID, fincen.gov. They're going to log in with the login.gov account. And if your client has global entry or pre-check or something like that, they probably already have a login.gov account to begin with. If not, super easy to create one. Then they'll themselves plug in all the information, upload their ID to the FinCEN website directly, after which FinCEN will issue them, I think it's 13 or 16-digit unique FinCEN identifier number. And then you can just plug that into the actual report. The idea being that if the client ever changes information, they can just log into the login.gov account, change it there, and all the reports that you filed, right, because you filed using that FinCEN identifier, that is, you don't need to do anything there. I mean, because it links back to the updated profile on FinCEN's website. So definitely recommend that folks get FinCEN IDs. There's also, like Antonio said, right, if you're a practitioner that realizes that, hey, I have to list myself as a company applicant, may be good for you to do that as well, so that you're not dishing out your information every single time on those reports. If you're having the client review those reports, those filings, I'm sorry, before we push them through to FinCEN. So FinCEN IDs are amazing. I think we go to the next slide, Antonio. Another point about FinCEN identifiers. So I mentioned that there are one or two instances where you may not need to list an individual as an owner, right, of a reporting company. This happens in two cases. If the beneficial owner owns or controls the ownership interest in a reporting company through an exempt entity, then you can list the information about the exempt entity, not necessarily that beneficial owner, in the reporting company CTA filing. And secondly, and this gets kind of convoluted and it has to be very fact specific, if the reporting company, at least a quarter of the reporting company's ownership interests are owned by a parent that shares the exact same BOIs as the reporting company, and if you have a FinCEN identifier for that entity, you can list that instead of the beneficial owners. So an example that I gave, right, where you had that 32% holder, the corporation, there was a mismatch. The owners weren't the same, so we had to go ahead and list out all of them. But in the event that they are the same, you can just swap that out with a FinCEN identifier if you have one for that parent entity. Okay. I think that, I think we can skip to resources. Next slide. All right, so these are, sorry, go ahead.
Oh, no, go.
I was saying, so these are the resources I've been telling y'all about that we get to eventually. So one is the FinCEN website, great FAQ on their BOI portion of the website, and also will help you get that FinCEN ID if you need it. It's also where you file the FinCEN CTA reports, right? Either through the website portal or through the PDF that they provide that you can fill in on your desktop and then upload for filing. The compliance guide is amazing. That is what has all the checklists and all the tests to help you determine whether or not you're a reporting company or B, exempt. So definitely download that. It's a PDF. I literally have it. You can't see it. Well, there it is. Yeah, I have it on my desk. I use it all the time. Very, very helpful. And then I think you want to take some questions?
Yeah, let's take some questions. Yeah.
I agree. You guys are doing a phenomenal job walking through such a complicated, simple act, which has a lot of underpinnings and, permeates through so many different practices. And you can tell from the questions that have come through, people are kind of thinking, how does this affect my practice? And let me kind of get some specific questions answered here. So you might have covered some of these, but some of these pop up as good ones to talk about. So I'll try to field them as best as I can. Regarding nonprofits, a clarifying question, if an existing nonprofit has a 1023 and regularly files their 990s, are they exempt from this act?
Yes.
Simple enough. The next one here is, if we file a FinCEN entry for an LLC, how can we find out if it was done correctly? Does FinCEN send a confirmation if it's correct?
Yeah, this is actually ran into this problem last week. Unfortunately, as of now, there's really no way to log in and get a copy of the filing. It'll give you confirmation the filing was made. It'll error out saying, hey, you've already reported something, so you can't file an initial report. You can file an amendment. So in our case, client didn't tell us, file the report. Thankfully, client had saved the copy of the report that it filed. It was inaccurate, so we went ahead and filed an amendment. And so this may not be the best advice in your particular situation, but if you feel like the report may have been filed inaccurately, if you just don't know, then an amendment might be the route to take. And again, if it's already been filed, it'll kick you out saying, hey, there's something already here. You can no longer file an initial report.
Perfect. Are clients allowed to make a business, quote unquote, FinCEN ID if they don't want to use one linked to something more personal like a pre-check? Instinct tells me that because they're linked to social security numbers, you can't have multiple FinCEN IDs, but want to confirm and get clarity.
I'm reading the question.
Want to try to get two FinCEN identifier numbers. And I don't think you can, because I think it is attached to your social security and ID for who you are individually. So that's your ID that you would use in different instances. So I guess they want a personal FinCEN and maybe a business FinCEN. Is that more?
I mean, you can have like the slide mentioned, you can have a reporting company FinCEN at times, right? When you file that report, you can request a FinCEN ID for that particular reporting company. Whether or not you could use it for future filings depends on, whether you meet the requirements to be able to list a FinCEN ID for a company on the actual application, right? Because most of the time, more often than not, you have to refer back to individual owners. But like Antonio said, for the most part, if you're requesting a FinCEN ID for personal use, it is tied to that social other unique identifier.
Got it. That makes sense. Couple of points on trusts. I guess we got a couple of questions on those somewhat together, Antonio. You hit a nerve, which is great to talk about because what you brought up was so key. The question kind of goes, must a BOI report be filed if a trust has an interest in the entity? But does the trust itself have to file the report, or is it tied to that LLC reporting that it's owned by a trust? I think if I follow the right logical end on that
Following your
question.
logic, then the example is if that trust, so you fund the trust by rolling over that entity into the trust. Now the trust is the owner. So the ownership stake is 25% or more. It meets that prong. And then if the trust also has that substantial control piece over it, then those trustees of that trust would then be the ones who would file the BOI reporting. Because now the trust is the owner. The individuals who started the entity are no longer the owners. The trust is the owner now.
Makes sense.
All right, thank you.
This one might have also been somewhat answered, but it's kind of tied to another question that came through as well. Is there a way to have the client, quote unquote, be the organizer if we're doing a filing through the SOS Direct website in Texas here? And a similar question is, what guidelines or rules might you recommend if the attorneys aren't the organizer and if the client signs the entity formation docs and faxes it himself to the Secretary of State? What kind of analysis should these practitioners be doing?
Yeah, I can speak to that. So before I answer that, I saw another question about company applicants. There's some confusion about that. So company applicants are required for filings for entities formed on or after January 1st of this year, right? I think there was some confusion that, hey, do we not need CTA filings for companies formed before then? No, you do. If you're formed in 2023 or earlier, you just don't need to provide company applicants, but you still need a CTA filing by the end of this year. So I just wanted to clarify that. Now, as the organizer, right? When I refer to organizer, I mean the client's actually signing on the dotted line, right? The certificate of formation, certificate of partnership, so on and so forth. That is the organizer for that purposes, right? Sometimes attorneys sign as the incorporator and then withdraw later on, right? But we just have the client sign those documents. We don't sign those documents. But that by itself doesn't necessarily absolve the attorney or the practitioner from being reported as a company applicant, because if the attorney is filing through SOS Direct, right, or paralegal is filing through SOS Direct, then that meets the second prong of, or the second factor of who is a company applicant, which is the individual primarily responsible, the individual service who actually physically electronically file the document. So that's why for us, if we ever have one of our attorneys or paralegals actually file the document through SOS Direct because we just needed it done ASAP, that would be a company applicant. So for the most part, we try to have only our third-party service make those filings, only have our clients sign on the dotted line.
Yeah. Yeah. And I'll jump in for myself. Me being more direct with the client, I am the company applicant sometimes because they're hiring me and relying on me to do the filing form or set up a series LLC form. So I'm the company applicant. So a FinCEN identifier number, again, is very crucial to me because that's what I'm going to provide the client. So when I set it up for them, normally I do the LLC and I give them a formation document, which says all their dates and filing dates. And I also include a memo that, hey, you have a Corporate Transparency Act that needs to be sent over and complied with. And this is the information that needs to go along with it.
Excellent. And I just wanted to make sure I put up the CLE code while we continue to answer these questions in case someone has to run. This is a self-reporting CLE code for Texas, 1742-48071. You can self-report for a 1-hour credit for CLE. Two other questions here. One, again, related to trust. What if the LLC has a POD, payable on death, to the trust? Does the trustee then need to file, or only after the death of the member managers of the LLC?
So think about this in my head really quickly. Right. So if the LLC, if their membership interest passes on the death, so then the LLC would continue to more than likely be the reporting company and report on its beneficial owners. Once they pass away, then that LLC then gets transferred or rolled over into the trust. And then more than likely, yes, whoever the trustee is at the time would then have to meet the guidelines and everything on filing the BOI for the trust. It would be an irrevocable trust then, so it could be a corporate trustee or someone, another family member, but they do need to comply with it.
And then the $1,000,000 question, do you have third-party recommendations to use for the CTA filings on behalf of our wonderful clients?
Jump in.
Yeah, so I do a lot of them, but associates. I do a lot of them, but sometimes, I mean, one third-party service that we use is Capital Services. I may not be a great fit for all clients, but unfortunately don't have much of advice there because it's mostly us that are. Sometimes the clients will do it themselves, and I guess for Waz, we're out of time, but I would have loved to show what the filing looks like.
Yeah.
But
maybe do a part 2.
We can do a part 2. Yeah, might be a quick part 2.
But like I know, like CT Corporation, Capital Services, they all provide those services.
So many.
Yeah,
they also give you the FinCEN IDs as well, if they're the ones that are doing those filings. So
even legal
and I've also go ahead. Sorry.
Oh, I was just saying LegalZoom, all of those places sometimes do it.
I think we got.
And I was going to say the wonderful part of these third-party services is they're trying to figure it out along with you as well. So they want to help you. You know, you can brainstorm with them. You just got a recommendation. V Corp is good too. I've used them before as well, so that came through on the Q&A as well. But yes, we are out of time. The super last question was, you know, will the materials be available? Will this be available? The answer is yes. It'll be in our DFW MBA Musim Bar website, where there are a bunch of other CLEs as well, so you can check them out at any point in time. I want to thank Cheyenne and Antonio for giving up their noon hour here to really educate us on a very complicated subject and illustrate how we all can benefit and be more aware of it so we can add value to our clients just in simple conversations of you thought about the CTA, and then say, no, what's that? And you now have hopefully a little bit of a nugget to say, well, CTA is this whole thing. So hopefully that'll be very helpful. And on behalf of the DFW Musim Bar Association, thank you two for doing this for us. And yes, we'll do a part 2 here maybe soon.
Thank you. Thank you.
All right.
Thank you, everyone.
Thank you so much.
Thanks, everyone. Have a good day.